An Introduction to Constitutional Law, 100 plus Supreme Court cases everyone should know, by Randy Barnett and Josh Blackman. New York State Rifle and Pistol Association v. Bruen, 2022. In the span of 2 years, the Supreme Court decided 2 landmark Second Amendment cases. District of Columbia v. Heller, 2008, held that the Second Amendment guarantees an individual right to keep and bear arms that is not connected to militia service. And McDonald v. Chicago, 2010, applied this right to the states via the 14th Amendment. The precise holding of both cases, however, was limited to the issue of whether the federal and state governments could prohibit the private ownership of handguns inside the home. Heller and McDonald did not address a broader question. Does the Second Amendment guarantee a right to carry a firearm outside the home? Over the ensuing 12 years, the lower courts would divide on this question. In New York State Rifle and Pistol Association v. Bruen, 2022, the Supreme Court held that the Second Amendment does protect an individual right to carry a firearm outside the home. Brandon Koch and Robert Nash are law-abiding citizens of Rensselaer County in upstate New York. They are members of the New York State Rifle and Pistol Association. Koch and Nash both wanted to carry a handgun outside of their homes so they could defend themselves. New York required more. Applicants must demonstrate that they have, quote, proper cause to carry a firearm. Specifically, Koch and Nash had to show, quote, a special need for self-protection distinguishable from that of the general community. It was not enough to show that they lived or worked in a high-crime area. Rather, they had to provide evidence, quote, of particular threats, attacks, or other extraordinary danger to personal safety. New York's law is known as a may-issue regime. That is, the state may issue a carry license at its discretion. By contrast, more than 40 states employ a shall-issue regime. Their regulations provide that the government shall issue a carry license if a person meets certain general objective criteria, such as passing a criminal background check or taking a training course. Koch and Nash did not have, quote, a special need distinguishable from that of the general community. They simply wanted to carry a firearm for self-defense. Therefore, a judge in New York determined that Koch and Nash did not demonstrate, quote, proper cause and denied their license. This denial was upheld by the federal courts. On appeal, the Supreme Court reversed by a 6-3 vote. Justice Thomas wrote the majority opinion, which was joined by Chief Justice Roberts and Justices Alito, Gorsuch, Kavanaugh, and Barrett. Justice Breyer wrote a dissent, which was joined by Justices Sotomayor and Kagan. The case involved 5 primary issues. The court began with methodology. In the decade following Heller and McDonald, the lower courts often reviewed gun control with strict or intermediate scrutiny. Justice Thomas's majority opinion rejected any means-ends balancing test. Instead, the court favored, quote, a test rooted in the Second Amendment's text as informed by history. Specifically, the government has the burden to, quote, affirmatively prove that its firearms regulation is part of the historical tradition that delimits the outer bounds of the right to keep and bear arms. Then, the court will, quote, assess whether modern firearms regulations are consistent with the Second Amendment's text and historical understanding. In dissent, Justice Breyer wrote, the judges are not equipped to, quote, resolve difficult historical questions, or to perform, quote, searching historical surveys. Indeed, during oral argument, Justice Breyer said the historical evidence conflicted with Heller. He recalled that
in McDonald, we had professors of history ran departments in the English Civil War, and they all said the history in Heller was wrong.
Breyer continued,
"This is a wonderful case for showing both sides. So I'm not sure how to deal with the history."
If the evidence is in tension, Breyer said, the court should defer to the government. Likewise, Justice Sotomayor added that
the history tradition of carrying weapons is that states get a lot of deference on this.
Justice Thomas disagreed. In his view, courts, quote, resolve legal questions rather than, quote, resolve historical questions in the abstract. And when the parties present courts with a historical record, courts can decide the case based on which party made the stronger case. Second, the court held that the Second Amendment protects a right to carry a handgun outside the home. Indeed, New York did not dispute this point. Justice Thomas explained that the Second Amendment does not, quote, draw a home-public distinction. The text refers to a right, quote, to keep and bear arms. And the word bear in the Second Amendment, quote, naturally encompasses public carry. But, quote, confining the right to bear arms to the home would nullify half of the Second Amendment's operative protections. Moreover, the need for self-defense, quote, and confrontation can surely take place outside the home. The court held that, quote, Koch and Nash have a right to bear arms in public for self-defense. Next, the court used analogical reasoning to determine if New York's proper cause standard was, quote, relevantly similar to historical regulations on carrying arms. During oral argument, Justice Thomas asked Paul Clement, the lawyer for the plaintiffs, about analogical reasoning.
If we analyze this and use history, tradition, text of the Second Amendment, we're going to have to do it by analogy.
Thomas asked Clement if he could
give me a regulation in history that would form a basis for a legitimate regulation today.
Thomas inquired,
if we're going to do it by analogy, what would we analogize it to?
In the majority opinion, Justice Thomas looked to potential analogies from 4 periods of time. First, the court looked to laws from medieval to early modern England. For example, the 1328 Statute of Northampton prohibited people from, quote, going armed. During oral argument, Paul Clement stated that the statute
was a prohibition on either carrying unusual and dangerous weapons or using common weapons in a way that terrorized the public.
However, there was another way to read the statute. Barbara Underwood, the New York Solicitor General, countered that carrying a gun would, by definition, terrorize the public.
Guns were deemed to be offensive weapons.
And thus, carrying arms was always prohibited. But the court agreed with Clement and determined that the Statute of Northampton only prohibited bearing arms in such a manner as to spread terror among the people. Justice Thomas jumped ahead to the laws in, quote, the American colonies and the early republic. During that period, quote, there was little evidence of regulating public carry by the general public. Prior to the Civil War, in antebellum America, state governments did enact restrictions on public carry. However, Justice Thomas observed, quote, none of these restrictions imposed a substantial burden on public carry that were analogous to New York's May issue regime. At most, quote, the manner of public carry was subject to reasonable regulation, but the states did not, quote, prevent law-abiding citizens with ordinary self-defense needs from carrying arms in public. After the Civil War, Southern states, quote, violated blacks' right to keep and bear arms. But these racist Jim Crow laws were not reliable evidence of how the right to bear arms was understood. And in 1866, Congress reenacted the Freedmen's Bureau Act. This statute expressly authorized the Bureau to protect, quote, the constitutional right to bear arms. According to Justice Thomas, limits on carry in other states were still, quote, consistent with a right of the public to peaceably carry handguns for self-defense. Finally, some Western territories prohibited people from carrying pistols. But the court dismissed the relevance of these laws, which, quote, appear more as passing regulatory efforts by not yet mature jurisdictions on the way to statehood. These laws were not, quote, part of an enduring American tradition of state regulation. Justice Thomas concluded that, quote, American governments simply have not broadly prohibited the public carry of commonly used firearms for personal defense. Based on this history, New York's May issue regime did not have an adequate historical analog. In light of this history, the court held that New York's, quote, proper cause requirement was therefore unconstitutional. In the fourth part of the majority opinion, Justice Thomas identified certain limits on its holding. The court did not cast doubt on the shall issue laws in 43 states. These laws, which often, quote, require applicants to undergo a background check or pass a firearm safety course, are, quote, narrow, objective, and definite standards. But the court counseled that these regimes may be unconstitutional if, quote, put toward abusive ends, by means, for example, of lengthy wait times or exorbitant fees. Justice Kavanaugh wrote a concurring opinion that identified two other limits of the court's decision. First, Kavanaugh wrote that states can require applicants to satisfy background checks, firearm training, as well as a mental health records check. Kavanaugh also repeated the paragraphs from Heller that approved of
long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places.
The majority did not comprehensively define the term sensitive places. The fifth element of the case focused on guns and public policy. Justice Breyer's dissent highlighted how many Americans were killed with firearms and the number of mass shootings. And he criticized the court for, quote, severely burdening states' efforts to reduce gun violence. For Breyer, judges should exhibit, quote, modesty and restraint when they interpret and apply the Second Amendment. The court rejected this approach to judging. Justice Thomas quoted from McDonald v. Chicago, quote, the right to keep and bear arms is not the only constitutional right that has controversial public safety implications. Moreover, Thomas wrote, the court should exhibit, quote, unqualified deference to the right of law-abiding responsible citizens to use arms and not to, quote, legislative interest. In the wake of Bruen, the lower courts will have to decide how to assess other firearm restrictions, such as bans on certain types of, quote, assault weapons, the scope of, quote, sensitive places, and the rights of former felons to bear arms. More generally, courts will need to wrestle with Justice Thomas's text and history alternative to the tiers of scrutiny. Study guide. Does Justice Thomas's text and history approach dispense with all means and scrutiny in the context of the Second Amendment? In other contexts, how would a court identify a regulation as burdensome or abusive?